I've just started recording the session, so some of you may have a pop-up in your computers to allow that, just to allow whoever wasn't able to join us today live to be able to look at the panel later. My name is Isabel Davila-Pereira. I am part of the CLAIHR board and the chair of the education committee. And I'm just going to do a little brief introduction of our event today and introduce each of our panelists. So first of all, I want to acknowledge that I am on Treaty 3 territory, which is located in what we know as Kenora in northwestern Ontario, and is traditionally the territory of several Anishinaabe nations, and also, of course, territory under Treaty 3. I approach my relationship to that as a newcomer and an immigrant, and so as a sort of modern settler, if you wish. So I try to uphold my obligations under the treaty and Indigenous laws, approaching it from that perspective. And I invite everyone who's joined us today to take a moment to reflect what their relationship to the land where they're located is. So today we have a very interesting climate litigation panel today. It's very interesting for me personally, but I hope that also, of course, for all of our members, given of the intersections between climate change and international human rights and human rights locally in Canada. So I will just briefly introduce our panelists, and then I don't want to take a lot of time. I just want to jump right in. So we have Andrew Gage with us, who's been a staff lawyer with West Coast Environmental Law for over 2 decades and is currently project lead for the organization's climate change program. Under Andrew's direction, the program has focused on the legal and professional consequences to industry, government, and professionals of failing to address climate change. Andrew was an expert witness before the parliamentary committees considering the Canadian Net Zero Emissions Accountability Act, which was enacted in 2020, and has published extensively on environmental and climate change law, including academic articles and most recently a book chapter on climate litigation and loss and damage. Next up, we have Bruce Johnston with us. Bruce is a lawyer at Trudel, Johnston, and Lesperance in Quebec. I am reading from your bio online, Bruce. He is a holder of a degree in history and is interested in the lessons of the past and concerned about the future. He worked on the Environnement JEUnesse case in Quebec, and will be talking to us about his perspective on that today. We also have Richard Overstall, who's joining us from out west. Richard's law practice has a particular focus on administrative, environmental, and land use law. Prior to practicing law, he worked as a mining geologist, then as a researcher for a number of public interest and Aboriginal organizations, including coordinating the expert opinion evidence for the Aboriginal plaintiffs in the Delgamuukw trial. He has developed the trust as a legal device for parties to cooperatively and impartially monitor whether the goals they negotiated in land use plans are being achieved, and has published in a number of legal research areas, including Indigenous law and history, global warming, criminal evidence, human rights, and monitoring trusts. Then we have Fraser Thomson with us, who has been a lawyer with Ecojustice for the last 9.5 years. He is a settler with a Scottish, Irish, and French heritage. For 7 years, he was based in Treaty 3 territory, working out of Ecojustice Calgary office, and recently moved back to his hometown of Toronto. His work focuses mainly on climate change and the impacts of coal, oil, and gas operations and transportation on communities, and has included leading Ecojustice's efforts in the Mathur and all chartered climate litigation case, successfully opposing a thermal coal export facility in Surrey, BC, coordinating Ecojustice's opposition to coal projects in Alberta and BC, and Ecojustice's law reform efforts to phase out coal mining use and export. He is passionate about infusing the law with environmental justice through litigation and reform. And prior to becoming a lawyer, he was involved in various environmental and social justice organizations. When he's not at work, he enjoys hiking, playing hockey, and trying to grow vegetables in his garden. And then we have David Wu, who's joining us from Arvay, Finlay. David has a broad civil litigation practice with a focus on public law litigation, and he has a particular interest in environmental rights and climate litigation, and is on the team in the La Rose case. He has appeared in all levels of courts in BC, as well as courts in Alberta and Ontario and the Supreme Court of Canada. David graduated in 2015 from the Faculty of Law of the UBC with a specialization in environmental and natural resource law. He also clerked at the BC Court of Appeal before being called to the bar in 2016. So I just want to thank all of our speakers very much for being here today. And I'll just move quickly on to our first panelist. If anyone does have questions, feel free to type them up in the chat and we'll go to them at the end, or you can just save them for our Q&A portion of the event. So I'll go to Andrew first.
Hi, everyone. Thank you for coming. I think you should be able to see my screen. Yes.
Yes.
Okay, great. I'm joining you from the territory of the Lho'imggin speaking people on southern Vancouver Island. My pronouns are he and him. You may have noticed I was the only person in the introductions there, the bios there, that didn't have a case attached to their name yet. I'm here as the part of the secretariat for the provocatively named Sue Big Oil campaign, which is pressing local governments in BC to file a class action lawsuit against global fossil fuel companies, but has not at this stage. There is no such case at this stage, nor would West Coast Environmental Law probably be the lawyers of record when it is filed. We're taking an external advocacy role on this. Over the next 10 minutes or so, I'm going to try to explain why Sue Big Oil is not just a campaign slogan, but also a legal recommendation and an important tool in protecting human rights. So in 1959, the physicist Dr. Edward Teller was invited by the American Petroleum Institute to speak at a conference on the future of energy. And at that point, he said, whenever you burn conventional fuel, you create carbon dioxide, contributing to a greenhouse effect. And he predicted that a 10% increase in carbon dioxide would be sufficient to melt the ice cap and submerge not just New York, but all coastal cities. So I'd like you to pause for a moment to think about the human rights violation, the mass displacement on an unprecedented scale that Dr. Teller was warning about in 1959. When warning oil industry officials. The science he was talking about, in which scientists, including oil and gas industry scientists, have been warning about for decades now, was the continued use of fossil fuels would continue to cause weather extremes to become much more severe and much more often, and much more frequent, as well as sea level rise, of course. And in the decades that followed, the scientists at Exxon and Chevron and Shell came up with very detailed predictions about the types of heat waves, the types of increased precipitation, extreme weather, and the other types of climate impacts that we would be seeing as a direct result of climate change, and predicting that those would be happening, certainly by now and getting worse. Scientists found that the 2021 heat dome, which killed, of course, more than 600 people, was 150 times more likely due to climate change than it would have been without it. The floods in the fall of 2021 were 2 to 4 times more likely, and the wildfires in 2017 were 7 to 11 times larger than they would have been without climate change. In other words, we know that global fossil fuel pollution is causing massive deaths, displacement, and human health effects. Similar effects are being felt around the world. Climate change is a human rights violation of unprecedented scale. And some climate scientists believing the civilization itself is at risk. So the class action that we've proposed and that we're calling on local governments to bring is a class action allowing local governments to cooperate together, brought by local governments, and I'll speak a bit about why local governments in nuisance, both public and private nuisance, for the cost of preparing for climate change and better protecting our residents, our infrastructure from the human rights and other the health and life implications of and displacement implications of climate change, against fossil fuel companies for a fair share of their contribution to the problem. Now, we're not the only ones saying that this is possible. At the launch of the Sue Big Oil campaign just on June 15th, Professor Stephen Wood of UBC spoke about an open letter that he and 27 other law professors had written to local governments, recommending that local governments must consider this type of litigation and that it has a reasonable prospect of success. As they pointed out, the alternative is that the victims of climate change and taxpayers ultimately pay 100% of the costs of climate change. Why local governments? The local governments, Vancouver has been grappling with the fact that it needs to pay over $1 billion in the coming decades to deal with rising sea levels. They're already paying over $50 million a year on climate-related costs. This is the cost of rebuilding and preparing for climate change. Similarly, Abbotsford has known for years, even before its recent floods, that it would be spending hundreds of millions of dollars to prepare for climate change. Those are extreme examples, but pretty much every local government across the country faces massive climate costs, whether it be in road maintenance, stormwater infrastructure, drought management, and the many other ways that climate change affects residents and municipal infrastructure. As I said, these types of impacts were predicted by oil and gas industry scientists in the 1980s, and we're now seeing them come about now. The Insurance Bureau of Canada and the Federation of Canadian Municipalities has estimated that local governments, in order to avoid the massive impacts of climate change, need to be spending about $5.3 billion each year to prepare for climate change. And a failure to spend those types of money not only opens up the local governments to liability, but also creates huge harm to their residents, massive displacement, climate-related migration. It can violate the right to life, exacerbate the spread of disease and species, disrupting entire ecosystems on a massive scale that has major human rights repercussions. Local governments are uniquely placed in that they have an obligation to protect their residents. They own about 60% of public infrastructure that was all built on the basis of certain assumptions about the frequency of extreme weather, climate, sea level rise, or sea levels. Those costs, the cost of actually rebuilding infrastructure to accommodate those additional extreme weather, those different that change in the range of what was historically the case, can be directly linked to climate change. And they have few other options to raise that additional $5.3 billion a year. Certainly, federal and provincial funding is entirely inadequate. Oh, sorry. Why fossil fuel companies? Well, we're always reminded that we're all responsible for climate change. The Onion has said sarcastic take on it. And of course, the oil company BP was one of the groups that was most responsible for popularizing the idea of a carbon footprint. The irony, of course, is that if you recognize that we are all responsible for climate change, then that means that the oil and gas industry is also responsible for climate change. And in fact, when you look at their role, their responsibility is quite a bit more significant than that of most individuals, or any individuals. The fossil fuel companies have known since at least the 1960s that their products were likely to increase global temperatures, resulting in sea level rise. And as I said, they had a detailed understanding of a full range of impacts by the 1980s. And they took that information, they chose to actively work against society reducing its fossil fuel use. Strategy that was developed by the American Petroleum Institute, Chevron, Exxon, and other industrial partners aimed to achieve victory by presenting those advocating for climate action on the basis of extant science science as out of touch with reality. And as a direct result, they made massive profits while worsening the climate crisis. Just 90 entities are responsible through their direct emissions and the emissions from their products for about 2/3 of greenhouse gases in the atmosphere today. Well, Canada has, the other cases we're going to hear about are mostly directed against the Canadian government, or in one case, the Ontario government. The Canadian emissions are about 1.6% of global emissions. Chevron's emissions historically are about 3.2%. And certainly if you add up any significant number of these companies, you can have a global effect that goes well beyond Canada's borders by suing global companies for the harm that they're causing in Canada. People, I think lawyers sometimes are initially like, well, is this really going to work? There's a growing body of case law internationally that holds that these types of cases are at least arguable. We haven't yet seen one of these cases reach fruition, but there have been a number of motions to strike that have been successfully defended against, or where they've been overturned. The basis or struck down. When the pleadings have been struck down, it's been on the basis of distinct features of U.S. law, for example, that don't apply in Canada, and the basic principles that do apply in Canada have been upheld. An exception to that is the Kivalina case, where I think they did find it was ultimately not justiciable, but many other cases, and increasingly some global cases, some international cases outside the U.S. as well, have held that this type of case can be heard. Although it's not a court tribunal, I do draw your attention to the National Inquiry on Climate Change from the Human Rights Commission in the Philippines. I'll talk a bit about that later. We don't have time to get into the weeds of exactly all aspects of the case, but I hope that I've sort of convinced you that there is something worth looking at further there. I do want to just say why, from a public policy point of view, we think it's absolutely crucial to sue big oil. And I think that really we have a society that largely separates the benefits and profits of the fossil fuel industry from the costs of their products, and the costs that our communities are experiencing from climate change, many of which amount to human rights violations. And the goal with, the courts have long had a role in helping identify and internalize externalities, with bringing costs and making sure that the costs of a product and of industrial operations reflect the true costs of that product. So the goal with litigation is to bring those costs together so that society can actually have an accurate picture of fossil fuels. Without doing that, fossil fuel companies appear to be hugely profitable. They're making record profits as we speak, unprecedented profits, all without paying for any of the costs associated with their products. And that results in governments thinking they have to continue to support this industry. It results in investors thinking they have to continue to invest in this industry, and it results in the public continuing to see this industry as an important part of the economy. Hurricane Yolanda, and after Typhoon Yolanda in the Philippines in 2013, a number of groups made a complaint to the Human Rights Commission there. And the Human Rights Commission concluded not only that climate change was violating the rights of the people of the Philippines, as I think can be demonstrated in this picture and any number of other pictures, but also that the global fossil fuel industry had played an active role in creating those human rights violations. Among other things, they found that the oil and gas industry and fossil fuel industry had engaged in willful obfuscation, I should have that word, practice, of climate science, and that they breached human rights. They also found that states have an obligation to have legal frameworks that allow for the compensation of the victims of climate impacts through courts or quasi-judicial bodies with revenues derived from polluters. Recognition there of the importance of this type of work in protecting the victims of human rights violations. And the report is well worth a read if you're looking at that intersection. Climate change litigation and litigation against these global companies is global in nature. Unlike most actions that focus on getting Canada or BC or Ontario or participating municipality to reduce its emissions. It is actually trying to create a global incentive and a global price associated with the harm that these companies are causing. Because local governments have suffered the harm here in BC, those global companies can be sued under Canadian law in BC courts. Yeah. It's also surprisingly popular when you ask the public about it. We've polled on this, and the BC public likes the idea of big oil paying its fair share, and even supports the idea of a lawsuit against fossil fuel companies by their local governments. It's important to note that fair share is very important here. Very few people, relatively small percentage of the public, think oil and gas companies or fossil fuel companies should be paying all of the costs of climate change. But many of them think that their contribution is significant enough they should be paying some of the costs. And the reality is, right now, they are just pocketing the profits. And then the benefits. First of all, we are finally talking about climate change as something deserving litigation, and really highlighting the local impacts and the human rights impacts associated with, and the legal impacts associated with climate change, even though the lawsuit we're proposing is not directly framed in terms of human rights. It certainly shines a light on those types of impacts. But also a class action lawsuit at an early stage requires the judge to confirm that there is a cause of action, that the case has merit. So right at the beginning of litigation, we would hope to see a ruling confirming that this type of case will go ahead, which then is a liability and a risk that the fossil fuel companies need to disclose to their shareholders, to their investors. And I think the hope is that we actually, both as these types of orders are made, or rulings are made, but also as the public increasingly sees it is sort of common sense that this industry should pay a portion of the harm that's being suffered, that this will actually begin to change investment decisions. And finally, when we win, we would see fossil fuel companies ordered to pay a fair share of climate costs. Local governments would have the resources they need to protect their citizens from climate impacts, and there would be a clear liability on the balance sheets modifying their business decisions. There's a precedent there that could be copied elsewhere, and there'd be pressure brought to bear for international climate treaties that would address the risk of this litigation by actually addressing climate change effectively. So if you want more information about the Sue Big Oil campaign, there's our website. You can also email either myself or the campaign generally. And I should say West Coast Environmental Law is one partner of this campaign. It's not just the West Coast Environmental Law campaign. And I'll pass it over to the next speaker and leave, maybe discuss it further when we get to the discussion, questions and answers phase. Thanks.
Thank you very much, Andrew. Seems you have frozen for me, but we will now hear from Bruce. And I do ask people if you have any questions and don't want to miss them, you can put them in the chat again, or you can save them for the end. One thing I will mention is we have activated the live transcript option. So if anyone needs support for subtitles or closed captions, you can just press the button now and that will be there. And just as a brief, better introduction than the introduction I gave about Bruce at the beginning, I will just mention Bruce was admitted to the Quebec Bar in 1993. He obtained his Bachelor of Civil Law and Bachelor of Laws degrees from McGill University, and he also holds, as I mentioned, a degree in history from McGill. He has been working representing clients at the level of the Supreme Court, the Superior Court, and the Court of Appeal of Quebec, as well as the Federal Court, and is frequently a guest speaker on the subjects of class actions, government liability, access to information, consumer protection, and international human rights law. Bruce is a lawyer and a partner, and he founded Trudel in Johnston in 1998 with Philip Trudel. I will now pass it on to you, Bruce, to tell us more about your work.
Thank you, Isabel. I apologize for not sending a proper bio. I know that you'd sent me an email asking for one, and I didn't do that. And I'm joining you from Fredericksburg, Quebec. We're right on the Vermont border. in the historic Abenaki land. My firm is specialized in class actions and in public interest litigation. We successfully sued the tobacco industry in Canada. We stopped the work of Energy East building a deepwater port in Kakuna. And because we lost our case in Environnement Jeunesse before the Supreme Court, we had time to take on a case on behalf of the CCLA where we invalidated the precedent of La Douceur in the Supreme Court, in which police is allowed to make stops which turn out to be racially motivated very often. So that's the good side of losing a case, is that you can take on another case. And the unfortunate side is that the objects that we were seeking to accomplish, we didn't accomplish. It's interesting to hear Andrew speak, because the logic that he explained on the motivation to take a class action was exactly the same as ours, which was you can get a rapid prima facie determination of the validity of your cause of action. And that was one of the reasons why we chose to take a class action. We were approached by Environnement Jeunesse, which is a long-standing environmental organization encouraging youth to participate in environmental action. And we took the case as a class action, alleging that the government was intentionally, knowingly setting greenhouse gas emissions targets which were dangerous, that they knew what the scientifically valid targets would be, but intentionally did not choose them, and that this constituted violations of the rights of Quebec youth to the protection of their rights under Section 7 and 15 of the Canadian Charter. And there are other arguments as well, but those were the main ones. And we proceeded to argue the certification stage, got a judgment in July of 2019. And on what we had properly identified, I think, as the main issue, the justiciability of our claim, we were successful in the Superior Court of Quebec because the judge stumbled on technical class action issues, which I'll spare you. But in our view, that was really, with all due respect to the judge, a pretext not to authorize the case, because it seemed very weak to us in law. But on the main issue of justiciability, we were successful. This actually led to a paradox for us, because on the main issue, we were not appellants. The Crown was, as cross-appellant. And so we appealed the technical class action issues, and the main written materials in the Court of Appeal focused on those issues. And the Crown focused on the justiciability issue, which they won on in the Quebec Court of Appeal. That judgment was rendered in December of 2021. We sought leave to appeal to the Supreme Court in February of this year, and were denied in July. And I must admit, we've sought leave to appeal in a few cases. Some you get, some you don't get. You sometimes get a feel for what should go to the court, and this case certainly met every criterion that I'm aware of. The fundamental issue, I think, is still out there, because thankfully there are other cases, which the main ones are represented here. And of course, we are very anxious to see how your cases will proceed. In our view, the justiciability issue is, in law, there's really no doubt that the case is justiciable. The relevant precedents, such as Operation Dismantle or Shaoli, which we argued, it leaves no doubt that once you have a clearly framed legal issue, the fact that it involves more political, moral issues, social issues, is not an obstacle to it being considered by the court. The scrutiny by the courts of the conformity to charter values of government action, once government policy has been translated into government action, that action is subject to scrutiny by the courts. Now, of course, we have no reasons for the denial by the court, and we did hear rumors that the court had enough of class actions, particularly class actions from Quebec, because there had been a spate in which many class actions from Quebec, well, several, considering the limited docket of the court, had been authorized. And we heard, sort of indirectly and sometimes almost directly, that there wouldn't be any more for a while. And maybe that's why, and maybe that's reason for others to hope. But it seems to me that if the court can hear 90 cases a year, a case which involves an existential threat to humanity should certainly find its way into those 90 at one point. We argued we think that there's a very strong argument to be made based on the greenhouse gas references, because the court did recognize in the references, first of all, the existential threat, but also, and more importantly, we think, the fact that federal action is indispensable. And if federal action is indispensable, our argument was that it is absolutely inconceivable that federal inaction, knowingly failing to act by the federal government, could somehow be not be subject to judicial review. And you know, the dean, now Justice Thomson, I think if we asked him directly, which we can't do anymore, he would think that this issue is clearly justiciable. And the danger that the doctrine of justiciability become an obstacle to the growth and proper application of the Charter is very serious in our society generally. And the other issue, which I think all of our cases raise, again, in and of themselves, constitute a very serious issue for the Supreme Court, is whether or not charter rights can impose positive obligations on the federal government. And in our view, there is clearly room for a determination of that. And given that in our case, we were at an arguable case stage, it's very surprising that the court not considered that you can at least argue it, and you can lose on the merits, but you have to be able to argue it, or else you will sterilize the Charter and its growth for the future. And in our view, the fact that there are many cases is very significant, because it is a clear sign that citizens are not satisfied with the means that are being taken by the governments to address this existential threat. And the fact that they are taking judicial action is a sign, is a symptom of a thirst for justice and a thirst for appropriate action. And I think that eventually the courts will, there will be a breakthrough on this, because it is too important. And the courts are the mirror of our society, not the other way around. And I think that there's a sufficient consensus in society that something has to be done. And the political process itself is deeply flawed in its ability to deal with this issue, because politicians are in power for a short time and seek to stay in power for as long as possible, but they're not looking to consequences 50 years, 100 years down the road, and they should be. And the Charter is one handle with which citizens can force them to address issues which will affect rights in the more distant future. And that's one of the reasons why we argued on behalf of youth, because they will clearly face the brunt, a disproportionate share of the consequences of our inaction today and our predecessors' inaction. And I think these issues are still alive. I think that the fact that the court hasn't heard our case does not mean that it won't hear it. I think that the issue of justiciability on the merits is a winning issue, and I certainly look forward to intervening on behalf of any case that makes it to the court. We feel that right now, as the case stands, the Court of Appeal in our case decided the issue solely on the basis of justiciability. And as such, that's a final judgment in our case right now. And we considered taking the case another way or framing it differently, not as a class action. And we've decided to hold off on that. But we certainly will be interested to intervene and assist in any way that we can, any case that can move forward. And that concludes my remarks.
Thank you, Bruce. Yeah, that's a lot of interesting remarks, I think, as it regards justiciability. I'm looking forward to hear what our other speakers' sort of experience with that issue has been, and maybe some questions at the end about how to overcome those challenges. So next we'll go to Richard. And I will share. Presentation.
Good morning. I'd like to start, introduce this case. The case right now is in the Federal Court of Appeal on the disability issue that Bruce has just been talking about. And we hope to have a hearing on that sometime this fall, although we haven't heard from the court yet, so I'm not quite sure when it's going to happen. So what I'd like to do this afternoon for you guys, is talk about a little bit about the points of the Lho'imggin case that might be a little different from some of the others. And the next slide, please. First, the plaintiffs. The plaintiffs are two Wet'suwet'en house groups. Wet'suwet'en house groups were part of the plaintiffs in the Delgamuukw case. I've known these guys for some time. A couple of things. As plaintiffs, they are suing on behalf of the houses, the chiefs, the two chiefs you see there, are suing on behalf of the house groups, which are constituted under their own indigenous law. And a couple of points there is, along with the health effects on individuals that climate change brings, there's really also their existence as legal, social, and cultural entities. Essentially, the kinship groups, which is what the house groups are tied to specific territories, and their whole legal system, social system, and culture depends on them having a relationship with those territories. And the photographs of the two plaintiff chiefs, Warren and Isabel on the left and Alphonse Gagnon on the right, that picture was taken on one of their territories. Next slide, please. I won't read out the bullet points, but point out that this case is about the constitutionality of greenhouse gas emissions controlled by the federal government. It's not about the constitutionality of legislated emission targets. The second point is that the standard required to ameliorate the infringement of the plaintiff's rights is a temperature standard, the well below 2 degrees temperature rise standard, not the annual emission standards. And I just wanted to say something about the Section 91 POG clause, which is one of the legal grounds that the plaintiffs are claiming. And essentially what we are saying that Section 91, the residual lawmaking power of the federal government for the peace, order, and good government of Canada, is those words have real meaning. For well over 100 years, the courts and a lot of academic writing on the POG clause talk about it being a sort of residual plenary lawmaking power. In other words, they're saying that the words peace, the word order, the words good government have no real meaning. And this is, of course, has always struck me is against the principles of statutory interpretation, but didn't seem to be anything that would go anywhere in the courts. Then in the last couple of decades in Britain, the words were given meaning by the courts there. In a series of cases called the Bancourt appeals, where all the indigenous people of an island archipelago in the Indian Ocean were removed from their homeland in order to make way for a US military base. And the people sued because the prorogatory order that removed them contained, in part, contained the words for the peace, order, and good government. And what the indigenous people there argued was that the removal of an entire population from their homeland constituted that the British government went beyond its peace, order, and good government powers. And that's the same argument we're making here. We take up the existential threat of climate change that Bruce mentioned to be something that is beyond the limits of the Canadian government's powers. So in that case, it's a little bit different from the usual charter claims that we make as well. But I won't go into those because a lot of people listening will be familiar with that, and other speakers will talk about it. Next slide, please. And this is just a little illustration of the, again, what Bruce mentioned and Andrew mentioned as well about the inaction of the federal government. Essentially, it shows the annual emissions from Canada for the last several decades, since about 1990. The red line at the top shows the actual emissions. The dotted black lines underneath show the various commitments on annual emissions that Canadian governments have made over that time period. And the green bars at the bottom of, in the lower part of the graph, show the annual emissions that would be required in order to meet the well below 2 degrees centigrade rise targets. So clearly, what the red line shows is for the last 30 years or so, the Canadian government has been unable or unwilling to meet any of the targets, and in any event, the targets, all the targets promised, including the Paris target, would be insufficient to meet the 2-degree temperature rise. What it also shows is that by essentially, to use the cliche, kicking the can down the road, that, as Bruce mentioned, and I'm sure David will mention, that it pushes the responsibility and the harm and the deprivation onto future generations, while our present generation continues to enjoy the so-called benefits of this high greenhouse gas emission economic system. Next slide, please. Essentially, as I mentioned, we're at the stage now where the plaintiffs filed their claim in February 2020. There was a decision by the federal court in November 2021, no, 2020, that struck the claim on the basis of a motion by Canada. And the three main areas they talked about was climate change as a political question, another legal question, that any charter challenge must identify a specific law or state action, and that there was insufficient causal connection between the harm claimed under Section 7 and Canada's greenhouse gas emissions. And as I said, we're currently in the Federal Court of Appeal, and hope to get a hearing sometime soon on that. And I just want, next slide, please. And I just want to finish up by, this is the quote from the federal court decision, and I think it gives us some insight as to what all this, in our view, what this justiciability argument is about. And what the motions judge said was, when the issue spans across various governments, involves issues of economic and foreign policy, trade, and a host of other issues, the courts must leave these decisions in the hands of others. And as Bruce mentioned, and as the chart showed, our argument is that the political system, both legislative and executive, is systemically incapable of dealing with an issue that is irreversible, where there is a time lag between the actions required and the impact of the actions, and which affects a global commons. So really, it's the court system, and in a constitutional democracy such as Canada's, reference to the Constitution, that is the only course, really the only course open to deal with the issue of climate change. So I was heartened by Bruce's remarks in terms of why his case, Lho'imggin, was denied a hearing by the Supreme Court of Canada. And hopefully we can proceed with this case on behalf of the Wet'suwet'en and House groups and some of the other cases that you'll be hearing about from the other speakers. So Isabel, I'll finish there and hand it over.
Thank you very much, Richard. It's very, very interesting to hear about your expertise and the approaches to the POG power, especially. I will stop sharing the screen now, and we'll pass it on to Fraser.
Hi, so can you hear me okay?
Yeah, all good.
Great. Okay, so yeah, my name is Fraser Thomson. I'm a lawyer with Ecojustice Canada. I'm joining you today from Treaty 13 Dish with One Spoon Treaty Territory, the territory of the Huron-Wendat, the Anishinaabe, the Haudenosaunee, and the Mississaugas of the Credit First Nation. And I'm going to take an approach that's a bit similar to Richard's in that I'm going to be talking about the Mathur case and trying to focus on how it differs from other cases, and largely echoing some of the comments that you've heard so far around some of the decisions that have come down around justiciability and some of the potential pitfalls and hopefully some of the remedies that will come through in the case law. In terms of contextualizing our case is a bit different. I thought I'd start with just a little bit of what it's going after. And that starts with Doug Ford in 2018. And in 2018, the Ford government was elected. They took climate change legislation that had been passed by the previous government that set in the legislation specific greenhouse gas emissions targets for 2020, 2030, and 2050, and set out the structure of a plan to implement those targets. The Ford government came in and repealed that legislation and replaced it with a weaker target, a target that would set Ontario's emissions at 30% below 2005 levels by 2030, which amounted to about a 15% decrease in ambition. So previous legislation was going to force Ontario to hit about 45% reductions. This reduced that ambition. So our specific action or our application looked at that action and said, this might be a way that we can address some of the justiciability issues and by targeting that specific action. We also thought that this regression of a target, so there's a principle, the principle of non-regression that says you have to continue to improve environmental progress on these kinds of things. It was violating that. And then the other piece of this is that by having a target to challenge, it was able to aggregate the government's actions into one specific case. The other reason we thought about Ontario is that Ontario has the ability to bring an application, a charter application. And so that's really sort of a technical procedural matter, but it allowed us to bring an application that would be a bit more expedited than an action. That said, there were, I think what we're all sort of trying to figure out is the best way, the best kind of case to bring. And obviously by targeting a specific province, there were other issues that arose from that. But that's generally kind of the background of why, rather than going after the federal government, we decided to go after the province and specifically the Ford government's actions in setting a lower target and repealing the previous target. We brought our case in 2019, and not surprisingly, it was met with a motion to strike by the Ontario government. The motion to strike was successful. Not successful. We were successful on it. It was unsuccessful for Ontario. And in Justice Brown's ruling on the motion to strike, there's really kind of two, I think, pertinent pieces that can apply for other climate cases. And the first was the way that she addressed justiciability I would definitely echo what Bruce was saying about how some of the other cases, how they've narrowly constrained, or they've used justiciability to say effectively that, you know, we can't look at climate change, and I think that's obviously unnecessarily narrow. When Justice Brown was looking at it, she really looked at the fact that you know, the case had targeted a specific plan and target, and that it was justiciable. But as we know, in the hearing, Ontario continued to argue justiciability, that the case was not justiciable, and so we'll have to see how the merits judge recognizes and addresses that. But I think the Justice Brown ruling, at the very least, provides a counterpoint to some of the points we've seen from other courts, that, you know, climate change is a complicated matter. No one's disputing that. But that doesn't mean that when charter rights have been alleged, that the courts should not step in. And in fact, that's their duty to do so. The other issue that was pretty, or that on which Justice Brown provided the bulk of her ruling, was in whether this was a claim that was capable of being proven. And unlike some of the other cases, our case was prospective. It was that the 2030 target will cause these harms, as opposed to, you know, the state actions have already caused some of these harms. And so whether these claims were capable of proof was indeed an important issue. Where I think our evidence was helpful, or our allegations, was that they're fairly reliant on intergovernmental panel on climate change science. And the judge, I think, took a lot of comfort in the level of scientific scrutiny that this science has. So for those who don't know, the IPCC is an international body under the United Nations. It's really the gold standard in climate science. And effectively, it takes some of the best available experts in the world, takes the best available science, and consolidates them into summary reports. And these summary reports are the synthesis reports of those, and the summary for policymakers are endorsed by all of the governments that are in the United Nations Framework Convention on Climate Change. So it really provides, I think, at least for Justice Brown at the notice to strike hearing, an ability to show that these claims were capable of proof, because we do know that there's cases in the jurisprudence, specifically Operation Dismantle, where courts have refused to hear something because the nature of the harm was so speculative. And as we put it, and I think as Justice Brown understood, and as the other panelists here have mentioned, you know, the level of scientific study of climate change is probably unparalleled. We know exactly, or to a great deal of certainty, that it's causing these harms, and that these harms will get worse. And that was helpful. Justice Brown addressed positive rights a little bit. We have our contention in our case is that this is not necessarily a positive rights case. That if you look at, you know, it's very tricky in Ontario to emit a greenhouse gas emission without somehow approval from the province of Ontario. You can't drive a car down a road without having a driver's license given to you by the province of Ontario on a road built by the Ontario government. And so for the Ontario government to say that, you know, we're only choosing not to act is to ignore that reality, that it's very hard to emit greenhouse gas emissions without the Ontario government helping you do it. But what Justice Brown said was that regardless of whether this is indeed a conventional negative rights case, if you believe in that framing, that as some of the other speakers have said, whether this case constitutes the special circumstances for a positive rights case under Section 7 is really only a question that can be determined when there's a full factual record. And that's necessary to do so. The other piece that I wanted to touch on, and so to continue with sort of the flow of the case, the motion to strike was dismissed. Ontario tried to appeal it in Ontario. because it wasn't a final decision on a matter, that Ontario didn't have an appeal as of right. And so they sought leave to appeal. Leave to appeal was denied. So the case went forward. The other piece that I wanted to touch on is what came next, which was the evidentiary process. And because I think there are a lot of lessons that were learned by our legal team in that, in terms of how to marshal this kind of evidence to show, to really answer the question, how do you effectively show that climate change will cause harms to Section 7 rights and Section 15 rights? And we sort of took an approach where we focused on, as I said, using the framework of the Intergovernmental Panel on Climate Change and adducing those reports, as was done in the agenda case in the Netherlands. But the reality is that those reports don't adequately specify the harms that would happen to Ontarians, the specific impacts of climate change in Ontario. So our second sort of grouping of evidence was government reports, so reports from the federal and provincial government that looked at what climate change harms would be. And there's actually quite a bit of really good government science. And unfortunately for our case, and this is something that I think can be very helpful for future cases, is the federal government is in the process of coming out with a bunch of different reports called Canada in a Changing Climate. And those are regional reports as well. So there's a report that is due on Ontario, there's reports from other provinces, reports on health, reports on all kinds of different impacts. And those reports are kind of the IPCC reports for Canada. So it consolidates the best available science, and I think could be potentially marshaled in a case, in some of the cases that we're talking about today. The last piece, and because some of this government reports weren't available, was specific experts. So we felt that it was necessary to have experts to provide issue-specific expert evidence. And so what I mean by issue-specific is we know some of the main harms that will be present in Ontario: heat waves, flooding, forest fires, infectious disease. We know that these impacts will have a disproportionate impact on Indigenous people. We know that there are all kinds of different other impacts other than those main impacts. And so we got experts to not only adduce what the best available science was on that, but to break it down by the different degrees of warming. So to show, if the world is able to stay at 1.5 degrees of warming, here are the anticipated impacts. If it warms to 2 degrees, here are the anticipated impacts. If it warms to 3 degrees, here are the anticipated impacts. And part of the rationale behind that was to be able to show the different harms that would occur based on the state's action. So if Ontario's, obviously there are a number of global actors here, but if Ontario's target, its fair share, is consistent with 1.5 degrees, versus if it's consistent with 3 degrees, we were able to show the different actual tangible impacts on Ontarians and then on their charter protected rights. So I think that's potentially a helpful tool for other cases. And I know I'm running out of time, so I'm just going to briefly address the hearing itself. So we had a hearing on the merits, the application. It was heard from September the 12th to the 14th of this year. Really, I mean, it's no surprise some of the issues that were really the focus of the questions from the judge and Ontario's arguments were around justiciability, were around causation, and really some of the questions that might come up today and between the different cases we have is this tension between attacking, a specific target versus the totality of the harm, because Ontario was saying, well, you've in attacking this specific target, you're not really capturing the totality of state action. And that's one of the tensions in the case law right now is, if we're seeing from some courts that you have to target a specific law, and if the court accepts Ontario's position that you can't just target a law, you have to target the totality, then we're at this paradox where the charter can't apply. And that's, I don't think, a satisfying result. And I don't think it's a result that's consistent with what the charter should be. Ontario is obviously arguing this stale argument around that their emissions don't matter, that, look at China, look at India, look at the US, which the Supreme Court, Canada, has done a good job at dismissing in the greenhouse gas reference case. So I think that's not an argument that I think will hold up. But we'll have to see in terms of when the decision will come out. It's likely, it's one of those things where it's anybody's guess, but our best guess is probably somewhere between 6 to 10 months after the hearing. So that puts us probably between April and July sometime. And then, we'll see if there's appeals after that. But as I said, this is, one of the pieces of all these cases trying to figure out, trying to grapple with some of these questions about how the charter is to apply, how the charter as this, the safeguard of our constitutional rights is to apply to the arguably one of the greatest threats to our fundamental rights in the 21st century. So we'll have to see. Looking forward to some of the discussion here today too.
Thank you so much, Fraser. That's a very, very interesting perspective and fits very well with what we've heard already today. I know I'm looking forward to the decision coming out. So now we'll move to David, last but certainly not least. We'll have David talk to us a little bit about the LaRose case and his experience.
Hi everyone, I'm speaking to you from Southern Vancouver Island, like Andrew today, on the traditional territories of the Lho'imggin peoples. So, LaRose was a case that was filed by 15 children, some of whom aren't children anymore, because it's been several years since it was filed, but 15 youths across Canada. It was a case that was inspired and modeled after JEUnesse, which is a case in the US, probably one of the most high profile cases globally in terms of this movement of children suing governments to hold them accountable on climate action. And just like the other cases, the main legal bases are Section 7 and Section 15 breaches. And the argument is that, Canada's actions, and I'll get to what those actions are in a second, but Canada's actions have contributed to climate change, which violate the plaintiffs' life, liberty, and security of the person under Section 7, given the harms posed to their, physical and psychological integrity and their ability to make fundamental life choices, as well as their equality rights under Section 15, given the vastly disproportionate impact of climate change on these plaintiffs and on youth in general relative to the older generation. Beyond the charter arguments, we also allege a common law argument in public trust, in that Canada had violated their obligations to protect public trust resources like the atmosphere or permafrost or navigable waters. That was kind of a novel argument that's was like the rest of our claim, unfortunately struck at federal court level. And the main reason why our claim was struck was, this claim was filed like all the other actions you've heard about today, prior to Canada enacting any one specific piece of legislation about climate change targets. And so, the Net Zero Act didn't come into effect until after our decision was filed and struck. And so in our claim, what we actually impugned was the fact that Canada had contributed to and allowed a level of GHG emissions incompatible with what we called a stable climate system, that they had adopted GHG emission targets that are inconsistent with the best available science about what is necessary to avoid dangerous climate system and restore a stable climate system, that they had failed to meet their own GHG emission targets, and that they were actively participating in and supporting the development and expansion of industries and activities involving fossil fuels that emit a level of GHGs incompatible with a stable climate system. And we term that impugned conduct. And ultimately, at the federal court level, I think it was that breadth of impugned conduct which really drove the the decision to stray our claim. Justice Manson found that because our impugned conduct was so broad and diffuse, it was effectively targeting all of Canada's policy response on climate change, an issue, and because of that, it wasn't justiciable. The courts don't have a role in taking over what should be Canada's policy response to climate change, and because that policy choice hadn't yet been translated into law, then or a network of laws even, that wasn't amenable to charter review. So that was really kind of the key finding. I mean, Justice Manson also took issue with our remedies and such, but I think that was really the issue he had with our claim the most. It's interesting, he did leave the door, because we did plead a positive rights claim as well, and he did leave the door open for that. Canada argued that there was no reasonable cause of action on the positive rights claim, but Justice Manson rejected that. And so that kind of brings up the interesting question of how you're supposed to plead a positive rights claim while attacking a specific law, because a positive rights claim would generally mean that there is no law and you're seeking the government to enact a law or to do something to protect that right. One of the other interesting things with this case and with all the other cases was, they all kind of went up at the same time and had kind of the same issues around them. And so there was quite a lot of, I think, interaction between the cases. So for example, by the time we were arguing our case in federal court, the Quebec case at the Supreme Court level had been decided, and we argued that. Sorry, my. So we argued that the court should follow the Quebec decision.
What are you talking about?
Yeah, that's really cool, buddy. I'm just doing some work right now, buddy.
What are you talking?
Yeah, I'm just gonna. Sorry about that. My toddler came into my room, but what I was saying was we were arguing that the court should follow Anjou, and Justice Manson dismissed that in his reasons. And didn't really provide an explanation why, except he said he didn't find it persuasive or applicable in our case. But then when the Quebec case went on to appeal, the Quebec Court of Appeal really relied, I think, quite heavily on Justice Manson's decision in finding the Quebec case to not be justiciable. So there's this interesting interaction where the federal court didn't find the Quebec case to be persuasive, but the Quebec Court of Appeal found our case to be persuasive. So that's something that's interesting. Our case right now is currently at the Federal Court of Appeal, and it's tied to Richard's case in terms of when it get heard. We still don't have hearing dates, as Richard had said. And I do want to leave some time for questions, so I'll just end with this thought. I think, hindsight's 2020. We have now 4 cases, charter cases on climate litigation in Canada, 3 of which have so far failed on justiciability on the basis of not impugning a law. Mathur is the only case which has succeeded, at least to get to the merits. And it's not the end of the road yet. Obviously our cases are still at the appeal level, and Mathur may be or may not be appealed or may not be successful on justiciability again, as it seems like Ontario has argued that again. But it does seem like, and perhaps consistent with other international cases like Urgenda and the Germany case in Neubauer, that it does make courts more comfortable when the claim is about legislation and targets. And that seems to provide the legal hook needed to make these kind of claims justiciable. I certainly agree with all the other speakers that I don't think it's a very principled reason why it's justiciable, but that seems to be the trend that it's headed in Canada and has headed internationally as well. So with that, I'll leave it with that and leave some time for questions.
Thank you so much, David. I'm just going to pin all of our speakers now. Let me see how I can do this. And I'll ask if anyone has a question. I'll just give our participants a chance to ask those questions first. So if anyone has a question, if you could just please click on the reaction button with the hand so I can unmute you. I see, Patricia, that you have probably the entirety of your class there adhering to us. So I'm happy if any student has any questions, we can also go there. Okay, I don't know, was that hand for a question or? Okay, so maybe we'll start with a question that we have on the side of CLAIHR. So a lot of the work we do, both as interveners and in education and advocacy, has obviously to do with international human rights law. So a key question we often have for panelists and in our events is, how would you grapple with the sort of international human rights law developments? How can we bring them home in a way? I'm thinking things like the UNDRIP Act, which starts advancing a little bit, at least for Indigenous rights, some ideas to the environment that may be able to be connected to climate change, or the newly adopted internationally right to a healthy environment. Do you see a space for that in some of the litigation you've pursued? And I'll let you each unmute as you want to answer.
I'll start there, Isabel. From my point of view, the difficulty with my clients, the plaintiffs in our case, is, as I said, they're constituted under their own laws. And essentially in Canada, we get strong resistance from both provincial government and the federal government to for Indigenous groups that are constituted under their own laws. They really like Indian Act band councils, or they like societies that are constituted on a tribal basis. So that's one difficulty. And in other cases, we've actually had challenges to Indigenous groups constituted under their own laws from the Indian Act band councils that claim to hold the Section 35 rights. And certainly my clients have seen that in terms of the impact benefit agreements that governments and fossil fuel companies have made with Indian Act band councils versus the resistance from the Indigenous constituted groups. So there's a real question as in terms of representation there that's difficult when dealing with either Section 35 rights or human rights that you mentioned, or under it, and the various pieces of legislation that flow out of the UNDRIP declarations.
Yeah, thank you, Richard. I agree. It's I face the same challenges every day in my work, even when we represent band councils with bringing along Anishinaabe laws in our cases as a valid basis in the courts for decision making and for legal responsibility. So I can definitely see that. I don't know if anyone else has something they.
I have a sort of a related I guess question maybe for Bruce, but also for the others. The Inter-American Commission on Human Rights has the ability, it's not binding, but it has the ability to consider human rights complaints where the Canadian courts have not successfully protected rights. Is there any thoughts on whether whether that's again not binding, but a possible avenue to if these to the extent these cases are struck down and are unsuccessful to hold the Canadian government to account?
We thought about it. We actually considered it and looked at the possible consequences, and one possible downside to going that route would be, in our view, the risk that the Canadian court system see that the whole object of our litigation is public relations rather than actually seeking a decision on a legal issue. And we were quite leery of that. And we thought better leave it for the courts to decide another day, in which case we can intervene and pool resources. But I think that there's a winning issue. Like, this is what my firm, we take cases we think we can win, and I was certain we could win this case, and I'm still certain that it's a winnable case. It's just we didn't frame it properly, or and I think that this exercise we're doing now is extremely useful, because I think that I agree with David. I think that the justiciability, we actually took both tracks. We challenged the setting of an inadequate target, but we also challenged the inaction to even meet that inadequate target. And I think that it's hard to say that both sides are not justiciable, or they can't be overbroad and too narrow at the same time. You can't win and lose for the same reason. So to answer your question, we thought about it and decided not to, because we thought better left for the courts, because it can be won.
Okay, thank you everyone for responding to that question. Yeah, on CLAIHR's side, I think we always try to look at the possibilities for the Inter-American Commission and for the Human Rights Committee, and how we can bring these types of challenges also at an international level. So it's certainly interesting to hear your perspectives on that as well. So I see we have 2 questions, so I'll let whoever in the class is asking to ask that question first, and then we'll read the one in the chat.
Hi, we have a question. So I'm Shereen, and I'm with the Transnational Environmental Law Clinic with Patricia, and we're from Windsor Law. And so we're curious about the different remedies that were sought in each case, and specifically how you strategically chose which remedies to pursue and why.
I can start. In LaRose, we kind of went for it all, which also proved to not be a smart move. I mean, we saw, a declaration that, the plaintiffs have a right to healthy, basically healthy climate system. We saw declarations that Canada was in breach of their Section 7, Section 15 rights. And then we also sought orders that Canada implement a plan, and the court supervise Canada to implement that plan. And these kind of supervisory orders do exist in charter law, albeit rare in rare circumstances. We thought this could constitute one of those rare circumstances for the court to exercise its supervisory jurisdiction. And Manson basically used the fact that we were seeking all these remedies to bolster the argument that we were effectively getting the court to step in the shoes of the government in deciding Canada's climate policy. So that wasn't necessarily the right approach for that court. But I mean, the issue of remedies on a justiciability stage, I don't think is even appropriately considered. I mean, whether remedy is appropriate or not seems to me to be more an issue at trial, and what kind of evidence is led and what kind of remedy should be ordered after you hear the merits. And I don't think it was appropriate to decide it or rule out certain remedies on a preliminary application like that. But we were wrong
So far.
so far.
We thought remedy, let's say modesty in remedies was a good idea in this case, because oftentimes in these types of cases, the courts are very reluctant to tell the courts, to tell the governments what they should do in any type of detail. So we sought a declaration that the targets set by the federal government were inadequate, and an order setting targets that were adequate and taking measures that would meet those targets. We also sought punitive damages, but that was more of an issue to bolster our class action procedural vehicle. But I think that the declaration, it's hard to argue against it, because that allows the courts to say to the government, I don't care what you do, but what you're doing now is violating the rights of these people, and so you go back to your working groups and you find some way where that's not going to happen. But we didn't get to that far.
In Mathur, we also tried to be as restrained as possible, but I'd echo, you should, if you're seeking a remedy, there's nothing not justiciable about that. Specifically, we had asked for a remedy that Section 7, Section 15 were violated. On the more direct order, what we sought was that the target be struck down. So the target under the legislation be struck down, and that it be replaced by a science-based target, which we thought about prescribing what that target would be, but thought potentially that would be maybe a little bit further than the courts wanted to go. Particularly, we had anchored it so much in IPCC science, where what a science-based target is not that controversial, would be determined in the court case, and would give the state enough discretion that the court wouldn't feel like it was stepping in, and that seemed to be enough, at least at the motion to strike, and we'll see on the merits where that goes.
Yeah, thank you all. And Andrew, go ahead. Sorry.
I don't have a case yet, obviously, but the case we're advocating for is focused on damages and compensation. Obviously, we've talked about injunctive relief against companies, and one of the leading international cases is actually the Friends of the Earth case, Milieu de France in the Netherlands, where they actually did get an injunctive order against Shell, which is obviously not on all fours with what we're looking for exactly, but did relate to their legal responsibility for the emissions from their products, which is very relevant to what we're talking about. But internationally, there's a whole body of case law about enforcing damages orders, court-ordered debt, that is much easier to invoke when it's about debt than whether enforcement of international injunctions is more difficult. There is some Canadian case law that's very positive on that, but most countries will not do it. whereas there are more options internationally to enforce a debt against a company. So that's why we focused on compensation, but it's possible that the lawyers and the municipalities that bring the case would choose to also include either declaratory or injunctive relief.
Yeah, I would just like to add to what the others have said. It's really important that in our argument, that the methods by which the Canadian government gets to a stable climate well below 2-degree centigrade rise is a political issue, and then the court's worries about dealing with relations with the provinces, with the economy, with trade, etc., etc. Governments can deal with that. They can do the negotiations, etc., etc. It's the end result that's important. And I think the declaration as a remedy deals with that. In other words, we're not saying government has to change its policy. It's already stated its policy in Paris, in the ratification by Parliament of Paris of the climate emergency declaration by Parliament. The policy's there. Also, the method by which they're going to get there is up to them, because as we argue in our cases, there's a multitude of pathways by which greenhouse gases are permitted or encouraged. It's just the final result that is important, and it's the final result that's causing the harm to all of our clients.
Yeah, thank you all for those insights. It's definitely a very interesting conversation, and thank you for that question. I know that we've reached the end of our time and have gone a little bit over it, so I'll let everyone go unless our panelists are okay with answering one last question. Okay, this is probably the last question just from the chat. Could you speak to the causation challenges that are raised and the strategies that could be adopted to address them?
I think that, as Fraser mentioned, the main causation argument was very well dealt with by the Supreme Court in the GGPA references, and it's a silly argument to say that if you only cause 4% or 2% of a problem, then you're exempt from any responsibility for it. But it is nonetheless extremely persuasive in public discourse, because that's all we hear. That's all we hear. We only contribute a small portion, and it's not going to change anything if we amend our ways. But that is just simply false in terms of causality. If you cause 1% of the problem and you know that you should do otherwise, then you have to stop. Period. And so but the Supreme Court really dealt well, I think, with that issue.
I mean, I think the causation challenges are perceived as being this big, overwhelming issue, but actually are not nearly as difficult as people think. I mean, that's not to say there are no challenges in particular cases, and it very much depends on what case you're arguing. If you're trying to show that a particular weather event was caused by climate change, that may be much more challenging, although increasingly there's science that actually could support that in the right case. I have a paper that actually I did for CLBC that if someone's particularly interested in exploring some of the causation issues, I could share. I mean, in water pollution and air pollution cases, historically, if you've contributed enough to a problem that your contribution is detectable, then you are a significant enough polluter that you can be sued for it.
Okay, yeah, I tend to agree with you, and I believe that the Urgenda case was actually pretty clear in sort of addressing that as well. So hopefully there will be a similar perspective now that we have the reference case here in Canada. So I want to thank all of our speakers today a lot for being here with us and taking the time. I think we've heard a lot of very interesting perspectives and the ways that all of your cases can interact with each other and have some common challenges and maybe some common ways to adapt and overcome those challenges. I hope that the participants enjoyed the event. I will mention this will probably be the first event of a series that we want to start on climate change and human rights, with the next event hopefully focusing on sort of international perspectives on climate change litigation. We'll hope to have some people who have participated maybe in the Philippines Commission, Mathur, and have some experience before the Inter-American Commission and the Inter-American Court in climate change and environmental rights. So thank you very much, everyone. I will conclude just by saying, because of the circumstances and context today, that CLAIHR, as an organization that advocates for international human rights, supports the QPA Ontario workers and who are striking today. And we believe that they have a right to protest, the right to unionize, and to negotiate their contracts and a strike. International human rights law protects those rights and recognizes those rights, and the government's use of the non-withstanding clause doesn't trump that set of international human rights law. Thank you very much to everyone. Have a great day. And we will be posting, of course, the recording.
Good luck to all of you.
Likewise, thanks.